wasn't sure. I'm used to being over here.
But he bought this building from my, it's all kind of a new thing for him. I have no issues with him whatsoever right now because I get to work, whereas I'm still dealing with the window folks. Some guy they pulled in randomly, want to come and talk to me all the time, and he shows up here, and I'm like,
On the
are you?
that is.
They kind of hired me to, I'm like, get out of here, you used car salesman. That's what I felt like saying, but it's all wrapped up, and I'm like, fine.
Where is that at? I saw some Crown.
And then the I Heart Mac and Cheese folks been playing phone tag. I call every morning. I call. He doesn't pick up the phone. And it's the father that calls. The father calls me. The son never calls me. It's the father. So tell me about the father.
Are you talking about the boards and commissions appointments? Okay, Darcy handed that. Then okay, that came in earlier, and then at 5 o'clock, another one came in that said he wanted all documents related to board and commission applications that were not.
I heard.
Or why I didn't forward them.
My sister called me today, the one that lives on Florida. She got a phone call, and someone on the other end said that they were conducting a survey.
And because he is failing my
Pretty good.
Having to go into the and giving them security devices for their home. More than that, ring doorbells and cameras and all this stuff.
You can pass mine now if you
I
want to.
got nothing.
Well, we got a donation from a church.
I wouldn't mind if you got an extra. I forgot to bring a printer. Thank you.
Coming through from
Hi.
wake up in the morning now. I've established a pattern the last 2 weeks.
Somebody donated a couple dozen to Urbana, so it might be related to that.
Well, she said, because she was asked, are you the one that made decisions in your family?
Yeah.
And she said, I can, but I talked to my husband first. And
Kind of.
I'll ask Carol, because I know we have, because they're sitting up in Kate's, they're sitting up in Kate's office. So
Paula goes up to do her thing. She wants you to sit up there with her.
but I didn't realize people were.
Be there, so she's right there. It's gonna be the threesome. It's mostly for noise.
Gotta make sure this microphone is not.
So if at any point you're like, if you're locking up, you just flip it to Dave, flip it to me. It's fine. If you feel like, oh, look, I need some space to think or whatever, it's fine if you want to do that. It's all, you're just doing an educational session. You are. You're gonna be great.
What's wrong? Oh, jeez. Oh, my God.
Used to work for the city of Dayton. Sometimes I always appreciate coming across people in the courts. This is one that he's told me that I'll remember forever, which is they can't. I understand. I can understand the perspective because I've seen that happen.
Getting a copy of the.
I get it. That's true. True enough.
Monday night. She's terrific. Yep. She's head and shoulders. We had 58 applicants, most of whom didn't even make the cut. But 11 were passed on by the search firm, and a bunch of them were interviewed, and she's clearly head and shoulders above the rest.
Where she, what was her previous?
I can't see this point. Yeah, but it'll be all public by Thursday when you get the packet. So.
Okay.
And she'll be at the meeting.
Lovely.
It's not, I mean, it's not gonna.
Your mind wanders to various places, trust me. It's,
when you're
been there, done that.
but anyway, she's terrific. So sure.
Say again?
Yes, please.
I'm not sure.
They don't do
They're
quite
gonna, well, they're definitely gonna do the promotion. I think they're gonna do the presentations first.
The communications. I have a
Guys, I don't think we're gonna have very much
all the concerns about the
public input, so.
He says, do you mind if I go first? No, it's going to be longer than 3 minutes. It's all relevant to what we've been getting.
Well, I think.
I know.
And the thing is, it's like,
And here's the most important sentence in that whole study, which should have been emphasized more, and that's on us. That's on us.
I mean, I can understand it has to be pretty distressing for.
Oh, yeah, yes. And part of it is the owner who is not being very. Oh, yeah, that's right. So you know. Which one? From who?
so,
That doesn't sound.
I didn't see one about sidewalks.
Very much
basically telling.
housing project kids are gonna come over because we're putting.
Oh, that one on Geraldine. That was last week. The one from last week?
Yeah, I guess it was last week, but after council.
Yes, I saw those. I was focused on this week, yeah. Well, a lot of unspoken things there, but.
Got the Raise 2.0 grant.
So that was part of Equal, and, you know, oh, you do have a quorum. You've got.
No, we don't have a clerk.
Oh.
So we need a.
There she is.
You know, I've got people asking like that.
Yeah, it was generated by the neighborhood, so, I don't know. Yeah, we have to see if that feeling is widespread or whether it's just one person.
All right, it is 7:01. I'd like to call the meeting of the Urbana City Council Committee of the Whole to order. Will the clerk please call the roll?
Ms. Wu,
Here.
Mr. Evans,
Here.
Ms. Hersey, Ms. Colasetti,
Here.
Ms. Bishop,
Here.
Ms. Wilkin, Mr. Quisenberry,
Here.
Mayor Marlin.
Here.
Thank you.
All right, the first item is the approval of the minutes of the previous meeting from February 6, 2023. Is there a motion?
So moved. Second.
Moved by Mary Alice and seconded by Chandra. Are there any substantive corrections? Seeing no corrections, all in favor, please say aye.
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 Any opposed? The minutes are approved. We have had a request to hold our presentations prior to public comment tonight, so we will start with the Urbana Fire Department promotion.
Thank you. Once again, the fire department thanks you guys for allowing us the opportunity to come and share our swearing-in ceremony here in this public forum. As you know, when our firefighters take an oath, this is their opportunity to express a specific intent to honor the commitment to this profession now and into the future for the duration of their career. Tonight, it is not a promotion that brings you here, but one of our new hires who's just finished a year on. And so I'm going to read tonight. Firefighter Wynn Burrows joined the department on November 8th, 2021, and successfully completed his probationary year, November 2022. Burrows served in the United States Army prior to joining UFD and is following in his late grandfather's footsteps, Chuck Beerley, who was also an Urbana firefighter for over 26 years. Wynn is a licensed EMTB, and is currently working on obtaining his paramedic license in order to provide the highest level of care to those he serves. Tonight, Wynn will be being pinned by his mother, Angie. So Wynn, if you can come up.
Please raise your right hand. I state your name.
I, Wynn Burrows,
Do solemnly swear that I will faithfully execute the duties of the position of firefighter for the city of Urbana in the county of Champaign, Illinois,
do solemnly swear that I will faithfully execute the duties of the position of firefighter for the city of Urbana in the county of Champaign, Illinois,
and will, to the best of my ability,
and will, to the best of my ability,
preserve, protect, and defend the Constitution and laws of the United States,
preserve, protect, and defend the Constitution and laws of the United States,
the state of Illinois,
the state of Illinois,
and the charter and ordinances of the city of Urbana,
and the charter and ordinances of the city of Urbana,
acting rightfully for the citizens of Urbana.
acting rightfully for the citizens of Urbana.
So help me God.
So help me God.
Congratulations.
Thank you.
Thank you.
Thank you.
Thank you very much. Thank you for letting us be part of this wonderful moment again. Next, we will have a presentation on the enforceability of the Human Rights Ordinance as related to source of income with Carla Boyd and Lily Walton.
I'm just going to give a little intro before they get started. And so what Carla and Dave are going to walk through tonight is some of the challenges that we've been facing. We've talked to council in briefings about this, and so we wanted to share some of those specific challenges with the public so they'll know, what we're concerned about. And Lily Walton is here from the Housing Authority, so she'll be available to answer any questions that you have. So this is really about an educational process for the council, again, members of the public, and we're happy to answer questions. But we now have a state law that has very similar language to our human rights ordinance about discrimination related to source of income in housing. And the state legislature had an opportunity to clarify what is, we believe is not clear in our ordinance, and they didn't take that opportunity. So we haven't gotten any more guidance with the help of the state law. So Carla's gonna walk through some slides, and then she and Dave, and as I said, Lily would be happy to answer any questions.
Thank you, Carol. Again, Carla Boyd. I'm the Human Rights. Bring it closer. I'm the Human Rights and Equity Officer for the City of Urbana. I've been here since May of 2021. And I want to walk through some of the Office of Human Rights and Equity's case background since I've been here. Since May of 2021, I have been able to do 16 formal discrimination complaints, and on the basis of these 5 criteria, these are the 5 bases that those complaints were. 9 of them were source of income, housing choice voucher, 3 for criminal records, 1 for ADA, 1 for race, and 2 for employment. Currently, there are 2 open cases for housing source of income and 1 for employment. And the office has received several calls for various complaints, but they weren't related to discrimination, and so I've just referred them out to the other organizations and agencies that would be able to help them address their issues. When I say no formal complaint filed, that's where someone has come into the office and we've worked through their issues and it didn't rise to the level of a discrimination case, and so we didn't file a formal case. When enforcing employment discrimination, there are standards and EEO guidelines are used. They have clear standards of proof, and with unlawful employment discrimination, the elements needed are very clear. One must be a member of a protected class. The discriminator knew of their protected class or classes. Act of harm or harms occurred. Others were similarly situated or were not adversely treated or accorded more favorable treatment. This process provides a clear path when a complaint of unlawful discrimination in employment is alleged. The Office of Human Rights and Equity uses the EEOC standards as guidelines when investigating complaints of whether unlawful discrimination has occurred. There are standards for enforcement of housing in general, the source of income in particular. Housing can be significantly different from employment. The city receives calls from individuals alleging unlawful housing discrimination based on calling or questioning landlords instead of submitting a formal application. It is understandable why one might do that, not wanting to go to the trouble or the expense of completing an application that may not be accepted. However, from an enforceability perspective, it makes investigating a discrimination allegation extremely problematic. Some notable characteristics that distinguish employment discrimination cases from the housing discrimination cases, 1, what constitutes an application? For instance, can one effectively establish a landlord discriminated against someone based on source of income if a landlord says, we don't take vouchers? What if that person didn't have a valid voucher in the first place? What constitutes a denial? Does a landlord deny someone housing if they actually never applied? Does the landlord have the discretion to decline to enter into a third-party contract, like the United States Housing and Urban Development Section 8 Housing Choice Voucher Program, or locally, the Home Consortium Lease Addendum? Are they bound to comply with all the terms of such agreements to ensure they are valid? I'm going to spend a few moments breaking down the 3 issues that I just described. My hope is that this information will lead to a greater understanding of how we can all work together to enhance compliance and facilitate more efficient enforcement. I also want people to understand the limitations of the Urbana's ordinance. It is immensely impactful if an application has been submitted in writing. That way it is clear who applied, when they applied, and more importantly, that they applied. Knowing the who and the when are especially important when it comes to source of income, because having a valid voucher is an essential part of that equation, and I'll explain that a bit later. Vouchers are valid for either 30 days or 90 days locally. The denial. When it comes to the denial, which is essentially, I think I might have, excuse me, I just want to make sure I didn't skip something. Sorry, I did. Sorry about that. When it comes to the denial, which is essentially the act of unlawful discrimination in a source of income case, it should be as specific as possible. The respondent has to show that the denial of housing was not based on an unlawful discriminatory reason. So the more facts that are documented and available in writing, the better for the complainant. HUD has issued guidance on what the standards are to establish a case of unlawful discrimination, and I rely on that guidance in my work. Undocumented denials, such as "we don't take vouchers," is very difficult to prove in a case of unlawful discrimination. I never deny a complainant the right to file a case. However, I do use those circumstances as educational opportunities to explain standards for burden of proof. Third-party agreements. In Champaign County, in order for the issuer of a housing voucher to accept a landlord's unit into the program, the landlord has to agree to participate in a voluntary program. For HUD-funded vouchers, the program is the Section 8 Housing Choice Voucher Program. Locally funded vouchers are through the Home Consortium. The program is outlined in the Tenant-Based Rental Assistance Policies and Procedures Manual. The TBRA vouchers are valid for 30 days, and the Housing Authority of Champaign County vouchers are valid for 90 days. There is some misunderstanding about what these voluntary programs require, which is summarized in the slide before you. The commitment goes beyond mere accepting the voucher as a source of income. It requires that the landlord submit to a quality housing standards inspection. If there are any deficiencies identified through that inspection, it requires the landlord to correct those deficiencies within 5 business days. Finally, there are up to 9 specific lease provisions that may not be included in the lease to the voucher holder. If they are included, they cannot be enforced. These provisions are largely related to legal protections for the landlord, to the disadvantage of the tenant, that the average renter may not understand. And I was reviewing them and I was like, I didn't know that. And so, such things as waiver of legal notice, excusing landlords from responsibility, and things, and et cetera. Based on the city's attorney's advice, we believe that the city currently does not have the legal authority to compel a landlord to participate in either the Voluntary Housing Choice Voucher Section 8 program or the tenant-based rent assistance programs. Not a surprise. Not everyone agrees with that statement. The following are some of the issues that have informed our position. Hayes v. City of Urbana. In 1997, there was a lawsuit captioned Hayes versus City of Urbana, Illinois. A group of landlords sued the City of Urbana because they did not want to accept the additional requirements that the federal government attached to the Section 8 program, beyond merely treating the voucher itself as if it were cash. At the time, the Urbana city attorney, I don't believe it was you, Mr. Not Mr. Wessner, stated to the court that he had no immediate plan to prosecute anyone for noncompliance with the source of income portions of the ordinance. Although the ultimate ruling was that the plaintiffs lacked standing because there was no prosecution pending, one issue that was raised that is relevant to where we find ourselves now: if a landlord wouldn't participate in the voluntary program, thereby disqualifying their property from being eligible for a voucher holder to rent, was a voucher a potential source of income for that property? Also, we have the new amendment to state law, HB 2775, that went into effect on January 1, 2023. Like Urbana, when it introduced source of income as a protected class, of which landlords cannot discriminate against potential renters, the state merely added source of income to the list of protected classes. The state did not address nor clarify the issue of whether or not the law makes a voluntary program mandatory. Now, locally, there are some really great programs available designed to increase the housing stock that is available for voucher holders. At the state level, we have the Housing Choice Voucher Tax Savings Program, whereby landlords can save up to 19% in taxes if they lease to a Housing Choice Voucher participant. Despite the change in the law regarding source of income, this program continues. On a local level, we have new incentive programs being offered by the Housing Authority of Champaign County. First-time landlords can earn up to $2,500, $500 per unit, if they begin to lease to voucher holders. For landlords who will re-lease a unit to another voucher holder after the first voucher holder vacates, the Housing Authority will pay 1 month's rent up to once a year. And the Housing Authority of Champaign County also pays incentives of $500 to $1,500 for units located in targeted areas. The Champaign County Regional Planning Commission has a landlord risk mitigation fund, which landlords can apply for funds to reimburse expenses to repair property damaged if the tenant is a Housing Choice Voucher holder. The maximum reimbursement per property is $2,500. The reason I'm calling attention to these programs, in addition to the fact that they offer really strong incentives to the landlords, their existence undermines the widespread view that the source of income provision possesses the strength that people believe it does. Why offer incentives if the law is clear? Between Mr. Wessner and myself, we have talked to many people that work on housing discrimination to specifically discuss this issue. Even though most of these people hold the belief that the state law gives local jurisdictions the right to compel landlords to participate in voluntary programs, none were willing to provide a legal opinion supporting that view. Moving forward for the Office of the Human Rights and Equity Office, we will ensure that everyone's right to submit a complaint is protected, and we will continue to provide this critical service to the community, utilizing all available tools and resources. We believe the best use of the city's resources is to assist residents in filing cases with the state when necessary, where more resources are available for the benefit of the complainant and other communities that are working through these issues. In closing, I've shared with you tonight some of the questions and challenges I have been working through since I came to the city of Urbana. I don't have all the answers, and I seem to have more questions than answers whenever I seek out answers. As an independent finder of fact for discrimination cases, I am not on the side of the complainant nor the respondent. I must ask the tough questions to get to answers that will help me resolve complaints. I look forward to working collectively to find answers to the questions that I have raised tonight and for those that will come. I thank you for your time.
Thank you for your presentation. Are there any questions? James.
Yeah, thank you for this. Oh, go ahead.
I just wanted to ask Lily if she wanted to join.
She's probably going to need to. Because my question is about the voluntary program. So if a landlord submits to the program and goes through the housing quality review, is approved, takes a voucher for a tenant, how long are they considered eligible? Do they have to submit annually to a review, or do they have to submit each time if they stop renting to the person that they got it originally for and they're renting to a new person? Do they have to submit again? And the point that I'm kind of getting at is, can a landlord do it for a while, and then kind of voluntarily withdraw, right? And I'm just curious about the timing of the reviews and such, and thank you for joining us to answer the question. I appreciate it.
No problem. So, excuse me, the landlords are, they can join the program, and generally what happens is a tenant has a voucher and they go out to find a unit, and they may find a unit that a landlord is leasing, and they'll tell that landlord, you know, I have a housing choice voucher, and that landlord would then have to sign a HAP contract with the housing authority and, complete the HQS inspection. And so there's not necessarily like a time that they're committed. It's really about, and this is one thing we try to stress to landlords, even though this new law is there, landlords still are given the right to screen tenants. They're not saying just because you have this housing choice voucher that you have to take that tenant, but you can still go through your normal screening processes and select the best tenant. But we're just asking landlords not to deny based on the fact that they have a voucher.
So if they've demonstrated that they're willing to take a voucher and go through this process, after that tenant leaves and the next person comes along, they would have to go through that process again for the next voucher?
Correct.
And they could say, I don't want to do it this time, and they would, there's no question. See, I'm worried about this situation where they might pick and choose which person with a voucher they want to participate with. Mm-hmm. And so I would say accepting a voucher is an indicator that you're willing to take that form of payment, but there is a path that you could be selective for other reasons and not continue to take vouchers. Is that the case?
I think that can be the case. That is the case. But when tenants, each tenant is treated as like a new, even if a landlord has rented that house or that unit out, for several years on the Housing Choice Voucher Program, each time a new tenant comes in, we have to go through that process again because it's all individual. And it's not extensive. It's just, a housing quality standards inspection. It's a lot less stringent than what the city inspections require. We're just checking to make sure that the unit is safe, decent, and sanitary. And, that there are no major issues that would prevent the tenant from living a healthy lifestyle in that unit.
But it's not like you're certified for 5 years. It's transaction-based. Each voucher is a new agreement with the housing authority.
Correct.
Okay, thank you. That's very helpful.
I would just want to add is that from what I have read through different cases, it's not, because I think your question was, do they have to do it in perpetuity, where they can't, once they start, they can never stop? That's unclear because we're not quite sure. It's a voluntary program, so the question that hasn't been clarified is, if I volunteer now, can I unvolunteer later? And so those questions have not been answered yet. And so it's hard to, with our new law, the new law says you must take housing choice voucher as a source of income, and it's being interpreted as mandatory for a voluntary program. But we're just not sure because no one has clarified that are you required to volunteer for the program, and are you required to remain in the program? Those questions haven't been answered.
Could I follow up? Yeah, I think that's an important point because I think in the case that happened in the 90s, one of the points were that state or local ordinances could not compel behavior according to federal law or federal programs. And so I think we're probably in the same place with a state law that it has that same kind of weakness. Is that correct? That it can't compel, again, participation in a voluntary federal program, which is the root of the issue here.
Yeah, Councilmember, and I appreciate the idea and the clarification from the point of whether you can step in and step out, ad nauseum, I suppose. And part of what I've reviewed too actually hit on that because there's a couple of cases commented that for state and local governments, if you looked at the federal regulations and legislation, there's nothing in there that says this transfers into a mandatory program if this set of circumstances exist, meaning you've got a state law or local law that says source of income is now a protected class. And so because it doesn't, it translates into, well, then what does that mean for purposes of this concept? And one of the things that people had commented about is now that the state has changed their law, it looks literally exactly the same as the cities does. It just added source of income in the idea of protected class, right? And so the question is if they had added another piece in there that said, we believe now that we've added this, it does mandate landlords to participate in the program, probably would have triggered an immediate response, I would guess, and it probably would have been helpful from the standpoint of trying to clarify this entirety of the program. And so it really stems from the fact that the feds have not changed anything in those regulations or those statutes that talk about this program to say it's voluntary unless this. They've not done that, themselves either. And so you're still now in this debate of, can states or local governments change that when HUD hasn't changed it itself?
Sharice?
One of my questions is, what are the 9 disallowed provisions?
I'm glad you asked that, because I just got them. They are found in, as I said, in the home consortium policies.
Mm-hmm.
It talks about confession of judgment, treatment of property, excusing the landlord from responsibility, waiver of legal notice, and then it gives explanations for these. Waiver of court proceedings for eviction, waiver of jury trial, waiver of right to appeal court decision, and tenant chargeable with cost of legal actions regardless of outcome of the lawsuit. And those cannot be enforced by someone holding a housing choice voucher. If they appear in the lease, they are not enforceable.
And if they're disallowed, why would a landlord even put them in the lease? I guess is the question that I have as well. Because these are disallowed by city, state, and federal, or just?
I think these are just provisions that appear in leases.
Mm-hmm.
And if someone has a housing choice voucher versus someone who's not using a housing choice voucher,
Mm-hmm.
those do not apply if the person is a housing choice voucher holder.
Okay. And my other question is, because what it sounds like is that most of this issue goes back to a federal level, basically. And sorry, what's your name again? Lily. Can you speak to that at all as to how that federal law is interpreted to the point where, or how it can be adjusted locally? So I mean, so that, I don't know if there's anything that the federal government can do to, or can say, or to make the city, the ordinance comply, to make them in sync. Let me put it that way.
I don't want to speak on that because I wouldn't know, to be quite honest. I know that there are things that the housing authority here locally can do to kind of support this new law and make it maybe easier for landlords to join onto the program, especially with our move to work authority and us being able to modify some of our regulations and rules. There's definitely some flexibility that the housing authority can do and that we are already doing to make this program, to make our program work with the new law. And so, but I can't speak on as far as what federally can be done. I know that every housing authority every housing authority director and staff are dealing with the same issues. And so here in Illinois, we're just lucky to at least have this start of the source of income protection law.
Okay.
And I thought I should add at this point, too, and I should have, in response to Councilmember Quisenberry, when Mrs. Boyd and I started having this conversation, it's been a while ago, I suggested to her, why don't we just call HUD and ask them, if this is in our ordinances, does this then translate into mandating landlords participate in the program. So I asked their general counsel, or one of their assistant general counsels, and they didn't answer the question. Frankly, I'll tell you, I wasn't surprised because I've had conversations with state and federal agencies before where I ask questions to try and get an answer or confirmation, and they don't do that. I think partly is they don't want to be called on the carpet for the answer they give, but all I got in response was some material to read. What it was a federal case and something else, and they didn't answer the question. It was what we've talked about in these cases. They're not definitive, and they don't suggest that it automatically translates into mandate just because that language happens to be in a state or local law. So that was unfortunate. I think it would have been helpful to get some of that direction from HUD when I asked the specific question, but yet they choose not to, definitively answer. Our perspective was as if there was some way to do that, the answer would have been, yes, of course, then it does translate into mandatory. And because they didn't, my only takeaway from that is that it doesn't make it mandatory. What I've suggested then is it comes back to just handling these situations as a general discrimination complaint. Complaint comes in, it's investigated, goes out to the respondent. They're able to provide their defenses to the nature of the claim. And you just walk that path in general versus the concept of now this just automatically requires them to participate. And then, in a sense, that would make this go away because if they're required to comply, when would you ever have a discrimination complaint come in for a source of income at that point? But, and so that's how I've suggested, we operate. Complaint comes in, we investigate, and we just go from there.
Thank you.
Mary Alice?
Hi. So, Lily, thanks for joining us tonight. You had used a phrase that we've been talking about this voluntary and mandated program, but you had also said that a landlord would have to sign a contract. You used that phrase, contract. So they have a legally binding contract if they are a part of the program. Is that correct?
We have a HAP contract, a housing assistance payment contract with landlords, and so it just really defines the relationship between the housing authority and the landlord. As far as they're required to, get the unit inspected, we're required to pay the rent or pay the rent, the portion of the rent that the tenant is not paying. And so it
kind of like
outlines
an
that.
addendum to a lease, it sounds like almost?
No, so the relationship is kind of like we define it as like a triangle, like there's a relationship between the landlord and the tenant, there's a relationship between the housing authority and the tenant, and there's a relationship between the housing authority and the landlord. And so that HAP contract really defines that relationship between the housing authority and the landlord. It has nothing to do with the lease between the landlord and the tenant.
Okay, all right. Carla, so I know we're talking a lot about source of payment, but you had also indicated that there were several other complaints in employment and so forth. And I'm wondering if you could speak a little bit to what the resolution, if there was a resolution to any of those other complaints.
It's been across the board. We've had complaints that have come in for source of income, for the criminal records. It's been, some were non-probable or no probable cause, some were probable cause, and some of the ones that some were reconciled or settled. So it's been across the board what the conclusions were. The ones that were source of income, probable cause, it was more efficient and easier, for lack of a better phrase, to be able to investigate and to come to a conclusion when the complainant had applied and we had a denial letter and reasons why the denial, and then we were able to go ahead and investigate that, and the respondents had to provide us with information on why it was not the reason that the person came in and said that they were denied housing for.
So at any time were you able to, were there any consequences to landlords who were found to have probable cause for discrimination?
We are currently in that process.
And then one more question for you, Lily. So there are all these kind of incentive programs or ways that trying to increase the number of landlords who participate in this program. I'm wondering if you have any idea of how many landlords you've successfully been able to sign up.
I don't have the numbers offhand, but I know we've definitely had an increase in new landlords, and then Housing Authority has also been doing quarterly landlord engagements, And so we've had a big turnout, especially with the new source of income law. We had a big turnout of new landlords who are willing to learn about the Housing Choice Voucher Program. And so on a quarterly basis, we do those landlord engagements. And we get new landlords all the time who are willing to come in and listen and hear about the voucher program, hear about the incentives that the Housing Authority are offering, provide us with available units to share with our voucher holders. And so we're seeing an uptick in it. I just don't have the exact numbers in front of me.
All right, thank you.
Chandra?
So with the increase in landlords, are you seeing an increase in voucher usage? I know before it was, the vouchers were out there, but they weren't getting used because they couldn't find homes.
Yes, utilization is up, and it's steadily rising. And so we're at about, I think about 85% right now. And we're looking to, we're getting ready to open our wait list again. And so we're hoping that with that opening, it will continue to see that rise in utilization.
Thank you.
Chris?
Thank you for the presentation. Is it okay for landlords to discriminate against source of income?
Asking?
Anyone wants to take that?
No, emphatically no.
Okay. Lily, you agree?
I agree that it is not okay.
In fact, I watched you, Lily, talk at the Champaign City Council where you complained about Champaign landlords discriminating against source of income. So I'm a little concerned about the direction. I understand the legal confusion, and I appreciate that. And how do we fix it? The other thing, too, and Lily, you might know this, maybe Tim Cowan knows this, but I remember the chief complaint about accepting the Section 8 voucher, as it was called then, was that the standards that the federal government had for your property was a lot higher than you normally could get away with when you rent to anybody else. In other words, the condition of your property had to be maintained and upgraded to a certain level. So I guess my question is there any difference between what the federal standards are under the housing voucher program and our just general habitable, building code standards? Are they the same? Do we have, as like in city code, lower standards than the federal government?
No, actually, I believe the Housing Authority, the HQS inspection, is a lot less stringent than what the city requires. And I can even say, at one point, Housing Authority had wrote into our MTW plan, we're allowed to, again, like I said, flex certain rules and regulations and policies. And we had actually wrote into to streamline some of the landlord complaints we were getting, we wrote into our policy that if it passed the city code, then we would, have a local inspection standard that was good enough. And so when we sent it off to HUD, that's when, this was many years ago, I actually wasn't at the Housing Authority at the time, so I can't explain the exact relationship.
Yeah.
But when we sent it off to HUD, we got feedback that actually said that it was requiring too much, and it would be too expensive and too much of a process to get people housed because of the city codes. And so basically, again, like I said, we're checking for basic things. We want to make sure all the outlets are working. We want to make sure that it's a safe place, a safe environment for the family that's going to be living there. And so our inspection is not to, we're not inspecting the roof to make sure that to see if it needs to be replaced. We're not doing those kind of inspections. We're just checking to make sure that it's safe and that it's habitable for the family.
Okay, so the voucher program can't be used as an excuse to say I have to keep my property. It's too expensive for me to maintain my property.
No,
okay.
not at all.
So on the denial, Carla, okay, forget a specific applicant, but there it is. The landlord is advertising in all their advertising, online, newspaper, flyers, whatever. We don't take vouchers. They're not just discriminating against one applicant. They're discriminating against every voucher holder, right? So what education are you providing at that point?
I would like to go to those landlords and explain to them that they are in violation of the law and what can we do to rectify that.
Okay,
so in violation of the ordinance if they're doing that.
So you're sort of saying you can't discriminate against
What I would
source
like,
of income.
what I would like to do is educate, not every person who is a landlord understands what the ordinance is. In my last 2 years that I've been here, I've run across a lot of landlords who didn't know what the ordinance stated. And so I wanted to provide them that education so that they would not be in violation of the ordinance unbeknownst to them.
Yeah, I understand that, but you are telling them, take it down, right?
Yes.
Okay.
Yes.
Um,
And when it comes, and if it's brought to me, yes, I do reach out and I say, this is what's been reported. Yes.
Okay. So, Dave Wisner, what's the fix here? I mean, do we need Carol Ammons to make them specify the law better, or what?
Honestly, and I only smile because I think the answer to that is not as simple as we would hope. I mean, as I alluded to earlier, it would be nice if the feds actually stepped in. If the feeling in general, and again, I assume, perhaps wrongly or rightly, I don't know, that the state believes that by putting that in the state law, it translates the voluntariness of the HUD program to a mandatory thing. But because it's not clear, it would be nice if HUD or the feds who run the regulations actually stepped in and did that, if they would provide that alternative. We believe this is a voluntary program, but for any state or local government that has the ability to enact this into a state law or local law, then it becomes a mandatory program for landlords in that state or that locality. Just as I sit here, I would imagine that now that the state has amended the statute, haven't seen it yet unless someone else has seen it, is landlord associations or groups may take them to task on the idea of this. If the state's belief is it does do that, I would imagine they'll take the state to task on that. I think it's beneficial to have the state take that fight on because it is the state. And if there's anybody that's going to have enough power to try and figure this out and get an actual definitive answer, it's going to be them. Not to say that it couldn't happen here locally in Urbana, but knowing the state took that step I would hope that, again, the thought process behind it and whatever information they had led them to believe they would be on solid footing if that got challenged. In that respect, that it's probably going to be, I think, the place to see it happen. If it hasn't happened yet at the federal level, because again, there are cases that talk about this in varying areas of the country, but still no definitive answer, I'm doubtful it will happen at the federal level. I think it's going to have to happen when a state has taken the step that Illinois did here and subject themselves to a challenge and just see how that plays out.
Thank you.
Sharice?
Just one more thing. So basically, you're saying that there will have to be a test case to go through.
I think, I don't know that there would have to be a specific single complainant, I guess, or single challenger to that. I think because it's such a broad spectrum of an amendment, that I would see it as a landlord association coming together and saying, hey, this impacts the entirety of the state of Illinois landlord folks, is that they would take a step into it and say, because it's such a broad stroke issue, let's go ahead and take this on. Typically what you find is that they file what's called a declaratory judgment action, and what it is we think there's an issue with this law. We need an answer. So we don't have specifics, but because we understand what is about to happen, we want a court to weigh in and tell us, we think it says this. State's probably going to say, hey, we believe it says this. And then they argue it in front of a court, judge decides, and it kind of takes that, particular path.
Okay.
James?
Thank you. One follow-up question. When we talk about, on the current slide, referring these to the state for adjudication, who at the state will do this? Is it the Attorney General? Is it, who prosecutes the case?
The Illinois Department of Human Rights, we will, what I hope to do is if a case comes to my office, is that we will contact the Illinois Department of Human Rights. They have an avenue for us to submit a complaint, and I will walk that complainant through that complaint and make sure that everything is in order so that we can submit it to the state, and then the state Human Rights Commission, they do that process.
Thank you.
Any other questions? Right? Thank you all very much. We will move on to public comment. If there's anyone who would like to address the Urbana City Council Committee of the Whole, please come up to the microphone and state your name for the record.
Hi, good evening. This is on, right? Okay. Good evening, my name is David Huber. I'm a citizen of Urbana. I had an obligation that prevented me from attending last week presentation of the downtown public realm study, but I watched the recording of the meeting. That was weird. I also read the draft study and attended a public input session with the consultants last year. So I'm an architect. There was an architect who gave other comment last week about the wind loads on walls. I don't want to address the council as an architect. Design and urban planning is one tool, but not, in my opinion, the cure to downtown's underwhelming public realm. We've commissioned and officially adopted plans and studies before: the 2012 downtown plan, the 2008 Boneyard Creek master plan. To what end? I am, or rather was, a critic and an editor. For 10 years, I wrote articles and essays pleading the merits of particular works of architecture, art, design, and the complex, dynamic role of culture in society, while resisting the kind of sentimentality that detaches buildings from their context, prevents urban spaces from evolving, and smothers architectural significance with historical designations. Designations often championed and weaponized by people who seem to dislike change as much or more than they appreciate fine civic architecture. But I don't want to address the council as a critic, however critical I may be. I'm also a small-scale developer here in Urbana, but I don't want to address the topic of downtown Urbana as a developer. In just a few short years living in Urbana, I've come to understand that downtown Urbana is toxic. Toxic as a place to invest money or develop real estate. In business, as in life, you choose your battles. Downtown Urbana is not a battle I want to fight. I could just tell by the way that people's eyes rolled or blood boiled when the names Alan Strong or Norman Baxley or Jim Webster came up among the energetic and enterprising under 60-year-olds that I respect and who are imperative to any so-called vibrant downtown. I could tell by how a small group of entrenched landlords freaking out elevates a temporary suspension of parking in one of many city-owned parking lots into a News Gazette-worthy story. Downtown just isn't very fun. Mayor and the City Council, I'm a citizen of Urbana, and that's what I want to address you all as. With regard to the public realm study that was presented last week, and just in terms of approaching the evolution of downtown Urbana generally. I believe the City Council, which to me is the safekeepers of the future of the city broadly, not just of downtown, but the whole city of Urbana, really needs to look at downtown from the perspective of citizens throughout the entire city. We heard from business owners, we heard from property owners, we heard from other so-called stakeholders. These stakeholders had their chance, they had meetings. But go and talk to citizens around the entire city. The mall or taking off the roof is not the one that comes up the most often. It's about the streets. It's about why are our schools in such poor condition? Why are we not able to raise a bond the way that Champaign can? Well, because our tax rate is so high as it is. These are concerns that concern the future of the city and determine whether people will live here, continue to live here, move here, etc. Talk to them about those problems. Last year, New Lincoln Square LLC, is the owner of the Lincoln Square Mall. They paid $50,548.20 in property taxes. I'm sure many people here have paid property taxes on their home if they own it, 2, 3, 4, 5. So 20 of us equal Jim Webster and the mall. So that's $50,548.20 for a 5.21 acre site in the middle of the city. Put this figure in the context of the entire area between Illinois, Vine, Elm, and Race, with its sea of tax-exempt, city-owned parking lots and federally owned courthouse, if you want to feel more depressed about the financial health of the city. To put this in perspective, 200 South Vine, right there, just across the street from the mall, from us, was billed $76,847.82 last year. Culver's on University, they paid $150.36. Lincoln Square's a problem. It's not just about the roof.
Thank you. I'm sorry, your time is up.
It's about the whole health.
If you'd like to submit additional comments,
of the
we'll gladly
city.
take them.
Thank you.
Thank you. Anybody else would like to address the committee of the whole? Please come up to the microphone. Anybody have any emails that were asked to be read out this time? No? All right. Thank you. We will move on to, are there any staff reports? Nope. All right. Then we have ordinance number 2023-03-006, an ordinance amending Chapter 21 of the Urbana City Code pertaining to land development and public works. Looks like we've got John and not sure who else.
Okay, good evening. All right, I'll pull up our meeting packet here. And I'm excited to present this ordinance to council, joined here by Joe Pasula, who has joined us as a temporary part-time employee, retired engineer who's come back to help us move this ordinance forward. Also joined by Tim Cowan, Public Works Director, and Kevin Garcia, Principal Planner, members of our team who worked on this over the last year. So, short story is, of course, we're presenting an ordinance that would basically take the place of the existing Chapter 21 in the city code, which pertains to land developments. This Chapter 21 was adopted in 1988 and was last updated in 1998. The city has made significant efforts over the past decade to update this chapter. This will be the last time I mention the pandemic. Pandemic definitely slowed things down a little bit, but we picked up efforts that were started before us and worked over the last year to bring them to a completed document to bring to you. So of course, what this chapter is all about is about regulating development, the development of land, which in the terms in the chapter is defined as changes to the legal rights or physical state of land, such as creating a substantial demand on public infrastructure in terms of stormwater demand, sanitary sewer demand, or traffic to the transportation network. Mining operations, I'd like to see when that was last enforced in Urbana, but mining operations, subdividing property in a substantial way, so even just changing the way the land is subdivided. So, an important, and aside from this just being an old code at 25 years and going, the important thing that we want to enact with this update is the introduction of a manual of practice. A manual of practice, when coupled with a development code, is becoming a more common organization structure that municipalities in our region are using. I'll list some examples of Champaign, Normal, Bloomington, Monticello, and Mahomet that have adopted this organization, where the development code is going to be the legal document, the legal ordinance that tells a developer what their procedures are, what are the steps they need to do, And then the manual of practice describes how they should do it. What are the technical specifications for design and construction? And so what that does is that puts the requirements, the procedures, and the steps that need to happen in city code, and then items that can change more frequently, such as the technical specifications. That puts that in an administrative document, the manual of practice. As an example, the way the manual of practice that we've drafted here be largely citing other technical standards that are in the industry, such as from the Department of Transportation for their design and construction, the Illinois sewer and water specifications for construction, documents that people smarter than us have put together that we look to as standards, and those standards get updated regularly. Some get updated yearly, others on 4 or 5 year basis. So there's definitely an advantage to have this manual of practice development code structure where we can be more nimble to update this manual of practice. And the way it'll be set up is that there was an administrative review committee, which is already part of our current development code, which is composed of the city engineer, the secretary of the planning commission, and the director of community development. These 3 individuals make up a committee that essentially reach unanimous decisions on administrative decisions, such as waivers or determining the type of development that a proposed development constitutes, whether it's a major development or a minor development, things like that. So we're going to continue to use that administrative review committee as the way that we make changes to the manual of practice as we go forward. And so in that vein, I apologize, my voice is getting hoarse. I'm sorry. Please let me know if I'm not speaking loud enough. And so in this vein, what we are proposing to you tonight is an adopting ordinances for the development code, the chapter 21 of the city code. The manual of practice is going to be issued by the administrative review committee as an administrative document, so it's not part of this discussion here tonight, except by extension of the aspects of the current development code that are being moved to the manual of practice, which I'll touch on in a minute. Okay. Just to touch on some of the steps we went through, I know that I shared it with, I know we shared it with council back at the end of January, our first draft of these documents. Worked with our internal team and with the city attorney to get the documents to you, and then we received input from members of city council as well as stakeholders from design engineering firms, contractors, and other agencies in the area. We're able to get input from the city of Champaign. It's kind of comparing notes with being similar with their current manual of practice and some of the changes they have proposed coming up this year. Also met with the Plan Commission, got some valuable input from them as well. And so what we're presenting you tonight, of course, is taking in those comments, and many of the comments that we received over the month of February we have addressed by revising the development code draft and the manual of practice. I will, of course, say that there were some comments that touched on issues that we consider outside the scope of the currently proposed update. A lot of them very good ideas, but we just wanted to table them for now, document them as comments for consideration for future updates. Just as, what we want to do is make sure we get an update to this document. We're not going to be able to solve all the problems that we have, but I believe that we have a really solid document before you that will definitely advance the city's cause here. Okay, so then on the adopting ordinance and just some highlights for some of the significant changes that we've made to the development code and the manual of practice. Oh, and I should say, I didn't mention it, but The current version of Chapter 21, you'll see it's titled the Subdivision and Land Development Code, and we made with some thoughtful input from the Plan Commission, chose to change the name to the Land Development Code because that's really what it's about. I mean, whether you think of it as something like a new subdivision that's being built on the outskirts of town, or there's redevelopment on the inside of town, they're all developments, and we're just talking about how do we develop land in a responsible, sustainable way in the city. So just thought it was an appropriate name change at this time. Okay, so touch on some stuff in the ordinance itself. Yeah, like I said, it basically just takes the existing chapter, tosses it aside, brings in the new chapter in its entirety. What we're going to do is, once council adopts this ordinance, of course it'll become effective immediately, but in practice, what we're going to do, we'll begin enforcing the ordinance for all developments with plats recorded after July 1st of this year. Or if a development has no associated plats, a smaller development will enforce it with any building permit applications submitted after July 1st. Just to make sure we give developers and their designers the chance to become aware of the changes before we start enforcing them. Okay. And now we have 73 pages of the development code. Just kidding. Let's see. Very close to the end there. Nope. Try again. Tim was giving me a hard time that said Carla was going to make me look bad because she had such a nice presentation. And I was like, I know I'm also not getting my PhD like she is, so I can't compete. But okay. And just first, I guess I could pause for a second. Are there any points of discussion or questions from council before I get into some of the details here?
Mary Alice.
So thank you. I know this was a long process, and I certainly do not have an engineering degree or a planning degree, so to take my questions as such, as I'm kind of a newbie here. So I've tried to stay away a little bit from like the distance of the sewers and all that stuff, and I'm really trying to look at process here. So the first thing that kind of came to mind was on page 16 of this, letter H. I don't know if it's 16 on your PDF, but it's 16 on this actual thing. That's 20, page, whoops.
Okay, I'm almost there.
And there you go.
Yeah.
So letter H, I thought this was interesting. Where this chapter conflicts with other codes, other ordinances, or the manual of practice, the provisions of this chapter shall take precedence over all others. This is the law of the land, basically. Is that right? Is that how I read that?
Yes, and
So we could pass another ordinance, but this one trumps it.
well, and I know our intention with this is that there's a hierarchy of, say, the kind of documents that would regulate the development itself. So for sure, like, it has authority over the manual of practice and over other standards that the manual of practice references.
But this overwrites the zoning ordinance, according to this H.
I'll call in city attorney for help on this one.
No. Hopefully, again, I always question myself on whether I'll help or hurt the conversation. But, Councilmember, what I would suggest is that the idea behind this is the things that are involved in this land development code and potentially the MOP are really what this is getting to. So in terms of the question about the idea, does this override the zoning code? I don't know if there's anything in the zoning code that would conflict with what's in here anyway, because zoning kind of is its own animal. But I think the concept would be is whether anything is currently in place or anything subsequent is adopted by the city council, that we would think through how to meld those together to the point that there's not inconsistency, and you end up having to figure out which one now does trump the other. Because I think this is more geared toward just the development itself, not zoning, not other stuff. Like, you know, I'm having trouble thinking of an example, I guess, on the idea of where there would be potential conflict, where that would be a legitimate concern is now we've got two things talking about the same concept. This one says it overrides, but maybe we think this one is actually more important, and oops, we made the mistake of this one says it overrides the other.
That's
So
my
I think
concern.
it's all about the idea of trying to meld everything together so that there's not inconsistency.
And I understand that as we update policies, there are other policies that are implicated that maybe they're now in conflict and so forth, but I'm very hesitant to approve this language as is. I would be fine with taking out other ordinances and just saying, where this chapter conflicts with the manual practice, this takes precedence. I think that makes more sense. It's clearer in terms of the intent of this. That would be one comment that I would have.
Okay, thank you.
And then, and I was trying to find, I apologize, I read this online and it's better to read it on paper. There was a statement, and I don't know if it was with the variances of minor or the minor developments. I can't remember if it was the variance or the development one that said that the manual of practice actually defines it and this ordinance does not. Do you remember which one that was?
Oh, okay.
Which surprised me.
Yeah, and that would not, well,
And I can,
don't recall off the top of my head. Let's see if I can find that.
well, it was basically that the definition was set by the manual of practice. I was like, but wait a second, this is supposed to set it.
Sure, sure. Well, I know that a minor development, so you got your hard copy out there, Joe, right?
That's
Oh,
all right,
get
I
the
will look
MLP
at
as
it and I
well.
will email you,
Okay.
depending on where we go with the vote tonight.
Sounds good. Yeah,
And
and
then I have one final question, is that okay?
Yeah.
Okay, so, you know, as I said, I was trying to look at process here, and as I understand it, you have 3 bodies that do approvals for this stuff, right? So you've got your administrative group, you've got the plan commission, and then you have the council mayor, right? So you've got
Correct.
3 different bodies, and they all interact in different ways with this.
mhm.
So with the minor variances, if I read this correctly, it only goes to administrative review.
Correct.
If it is not unanimous, meaning not everybody voted yes, right, or everybody voted no, then it goes to the plan commission.
I believe that is true.
And then does it go on from the plan commission to city council? Or can the plan commission make the final determination?
When there was when there was not unanimity about a minor variance.
Correct. Who makes the final decision?
Yeah, that's a good question. I didn't tested that case in particular. No, that's a great question. I'd have to run it through the procedure to see how that plays out. I don't know off the top of my head.
So a major variance cannot be administratively approved. It has to go to the plan commission, which then also has to go to city council.
Correct.
Okay. And are there, what other, I think if there was a disagreement in terms of whether it was a minor or a major development, there was a process for that as well, and very similar to what I just outlined with the major variance, if I remember correctly.
Because it is also, the determination of the type of development, yeah, is by the Administrative Review Committee as well. And so, yeah, in case of conflict, it's an excellent question.
Okay.
I'll have to become educated about that. Okay.
All right. I had another question, but I'm gonna let other people ask their questions.
Any other questions?
Well, there's no other questions.
Well, Mary Alice.
But I gotta go find my last question here. I tried to fold over my pages here. Yes, I remember. All right, my favorite topic, PUDs, plan unit developments. So, as I read this, plan unit developments have their own kind of rules, so to speak. So we have minor and we have major developments, and then we have plan unit developments. So there's 3 different kind of developments, right, that this land use talks about.
I would say that plan unit developments are a special case of a major development.
Of a major development.
They are a special case of a major development.
Okay. And that whole, because we have, this is where the zoning ordinance comes into play here.
Sure.
There's a whole bunch of stuff about PUDs in the zoning ordinance. But I really don't want to, I want to ensure that the public understands how the PUDs will be treated, right?
Okay.
And so having the zoning ordinance of the PUDs and what the proposals are here, really I think what's important to the public is to understand where they can have input. So I'd like, if possible, I would like to see that kind of outlined. I think what it says here is that PUDs go to the Plan Commission, and then the Plan Commission makes a recommendation and then gets voted on at City Council. There's the final and the proposed, right? And those have different levels that goes on. One of the things that happens with PUDs right now is that both the proposed and the final keep coming to the Plan Commission at the same time, which the public doesn't like.
Okay. Okay.
Okay? So how can you have a preliminary and a final in the same meeting?
Right. So you're talking about like the plat, like preliminary and final plat?
No, the
combined?
development plan. So in the
Development plan,
zoning
okay.
ordinance, you can have both the preliminary and the final in one meeting.
Mm-hmm.
I don't think you can do that here, but I would like to understand that a little bit better.
Okay. I understand your question. Yeah.
Thank you.
John, you want me to jump in? I'm the voice from the side of the room.
That's why Kevin Garcia is here.
That's right. Yeah, so Mary Alice, the procedures for going through a planned unit development are laid out in the zoning ordinance, and it does require a preliminary and a final planned unit development, and it does, as you said, go through Plan Commission and through City Council. The reason that we've been seeing the combination of both the preliminary and final coming straight to Plan Commission and straight to Council is because most of the planned unit developments that we've seen in the past 10 plus years have all been sort of infill development on smallish lots. They still have to be half an acre big, but they're lots that are already in areas of the city that are developed. So it's maybe a few parcels here or half a block there, maybe even a full block. But the way that PUDs are conceived and the majority of the language about them in the zoning ordinance is really imagining that they're going to be built in phases, sort of out in a former agricultural field, like on the edge of town. So they're conceived that they would be a much more massive development than the type of PUDs we've been seeing. So the reason, again, that we've been seeing the sort of combination is just because they're sort of smaller types of PUDs.
I guess my confusion here is that you have both the development, the land development, PUD kind of criteria, and then you also have the zoning ordinance PUD criteria, both going to the Plan Commission and City Council, and how those interact with one another is a little perplexing to me at the moment. I need to draw a diagram to figure out the whole process.
Any further questions, or do we have a motion?
I'll make the motion to send ordinance number 2023-03-006, an ordinance amending Chapter 21 of the Urbana City Code pertaining to land developments to City Council for approval on the regular agenda so that Mary Alice can have her questions answered.
Is there a second?
Second.
Moved by Chandra and seconded by James to move, excuse me, ordinance number 2023-03-006, an ordinance amending Chapter 21 of the Urbana City Code pertaining to land development onto City Council on the regular agenda. Was that for approval? Mm-hmm. For approval. I think that I would agree getting that clarification is important. Since this is an ordinance, will the clerk please call the roll? Oh, Mary Alice, sorry. Sorry, discussion.
Thank you. I am fine with sending this on to City Council. I will say that if we can't come to some kind of agreement with which ordinance takes precedence, I will be voting against it because it's very meaningful to me, that piece. And then I do have that other question, but since I don't have it outlined for you, I will definitely call you or email you the specific one that I was asking about. Those two were my primary concerns, in addition to just kind of understanding the different levels of approvals and so forth. So that's where I stand. So I will vote yes to send this on to City Council, but I will vote no against it if we don't get some clarity.
Thank you. Sharice.
I just want to say, because we did have this, discussion in our 2x2s and stuff, and what I really am taking into consideration is the fact that we're also doing some tweaking of our zoning ordinances right now as well, and so I kind of want to actually see how the two can coincide or can work together, and Mary Alice bringing up, which is a question that I was going to ask too, bringing up the whole thing about what trumps one and all of that kind of stuff. I really appreciate definitely the manual practice, but I also would like to see there be more cohesiveness regarding this and how it's going to affect the redefining and restructuring of our zoning codes that we're doing also right now. So, that the planners are doing right now, or somebody. So, I'll vote to send it forward, but I don't have a problem keeping it in committee for a while until I can see some more definition of how these two things are going to work together, or are we going to constantly be having to amend one or the other? I don't want to have to do that. I'd like to be able to see that one works inside and with the other. So that's my concern. So
Thank you.
Any further discussion? I would echo, again, getting those answers to the questions that Mary Alice has raised, especially as it relates to other ordinances, I think is really important before any final vote. But I think otherwise we are at a point where we are ready for the clerk to call the roll.
Ms. Wu?
Yes.
Mr. Evans?
Yes.
Ms. Hersey?
yes.
Ms. Colasetti?
Yes,
Ms. Bishop?
Yes.
Mr. Quisenberry?
Yes.
that motion passes. Thank you. Next, we have resolution number 2023-03-014R, supplemental resolution for improving under the Illinois Highway Code state motor fuel tax for Boneyard Creek Crossing Bridge repair. And we've got Public Works again.
Okay, thank you. I'm just going to camp out here for a little bit. Thank you, Joe. And now for something completely different. So we have before you 3 different resolutions related to the state motor fuel tax. They are all supplemental resolutions as we are making some changes later in our fiscal year here that I'll state this real briefly. Some of you are probably already very familiar with this, so sorry if this is redundant, but I'm going to use 2 terms, appropriation and budget here. And what I'm going to refer to as appropriation is funds that are set aside, that IDOT sets aside for us because council has passed a resolution saying, IDOT, we want this much money out of the state motor fuel tax fund. So that's appropriation is on IDOT's side. I'm going to use the word budget to talk about money that's on our side of the fence. So it's in our capital improvement plan. It's in our Munis accounting software. And I bring this up because there's going to be a couple of items here in 2 of these resolutions that come up where in our city's finance policy, say I have a budget of $100,000. If I get a bid for a project in at like $105,000, I can do a budget transfer to increase that fund by $5,000 because it's less than a 10% change. So there's some flexibility built into our policy that allows me to make those changes. But if I had passed an MFT resolution for $100,000, I have to do a supplemental resolution to get $5,000 more. And so part of this is that newbie city engineer didn't understand that about a year ago. And so some of these supplemental resolutions are just kind of providing that space for us to work within our policy by using this IDOT money. So, so I do apologize. I know some of this may seem a little confusing, talks about budgets and appropriations, but wanted to kind of lay that out really quick. So, okay, so for the first one, the Race Street Bridge over Boneyard Creek. It's in our CIP under the Boneyard Creek Crossing Project, kind of conceived of multiple improvements that we see, repairs, enhancements to the Boneyard Creek Crossing to increase and improve its utilization, as well as maintain the existing infrastructure in good condition. So for the Race Street Bridge in particular, this is work that we can use state motor fuel tax funds for. And so back in August, you'd passed a resolution for $55,000 for design of the bridge repairs. And that was the appropriation was for $55,000. Unfortunately, that was also the budget as well. And so when we got an actual quote for the work, as we went to more work defining the scope with an engineering firm to identify, you know, the repairs and the design and whatnot, we have a quote of $75,000. So we will have to come back to you in April for a budget amendment. But for now, I wanted to set up the state motor fuel tax resolution, supplemental resolution. And so what I will ask for here is an additional $30,000 as a supplemental resolution. This will provide us a little bit of space in case something unexpected comes up during design. And then once we have that design, in particular for bridge repairs, a little harder to project what the construction cost might be if, compared with, say, like a resurfacing. It's fairly well-defined piece of work. The bridge repairs can be pretty variable until you get the design really put together. So we'll be coming back to you with a budget in the next capital improvement plan for that. But for now, just our request is for an additional $30,000 as supplemental MFT resolution for the Boneyard Creek Crossing bridge repair design.
Any questions?
Make a motion.
I'll take a motion.
All right. I will move resolution number 2023-03014R with supplemental resolution for improvement under the Illinois Highway Code for the state motor fuel tax for the Boneyard Creek Crossing Bridge repair design onto the consent agenda at City Council meeting.
Second.
Moved by Mary Alice and seconded by James. Is there any further discussion? All those in favor say aye.
Aye.
Any opposed? That motion passes. Next, we have resolution number 2023-03-015R, supplemental resolution for improvement under the Illinois Highway Code state motor fuel tax for Savannah Green Alleys rehabilitation construction.
All right, thanks. And so carrying on from that theme, this is an example where for the Savannah Green Alleys, we are, for this in particular, we have the bid documents are nearing completion. We plan to go to advertise later in April and open bids in early May. We're sticking with our original budget of $1.95 million for engineering services and construction for this project. What we want to do is ensure that our we have enough MFT money set aside so that if we need to have a little bit of contingency during construction for example, an unexpected, utility relocation or something to that effect, that we have the flexibility to do that during construction. I don't have to come back to you during construction to ask for a little bit of that. So this is basically a request for a supplemental resolution to appropriate an additional $200,000 to provide some contingency for construction as we go into construction later this year.
Is there any discussion or a motion? Shreves?
I do have a question. Why are Gregory to Kohler excluded from the resurfacing?
Sure. So that is for the next resolution for the Springfield Avenue resurfacing project.
Oh, I'm sorry.
That's okay.
Am I looking at the wrong thing? I'm looking at the
All right,
wrong thing.
we're on Savannah Green alleys. Yep.
I'm sorry. Oh, my God.
I will gladly answer your question in a few
James.
minutes.
Thank you. I do have a question. So this is asking for approximately 10% contingency
Approximately,
for
yeah.
this project. What's the practice? I assume if that is not needed, that just stays in the motor fuel pool.
That's correct, yeah.
Goal is to not spend this 10% and not have any surprises that requires it, correct?
That's our goal for sure.
All
Yep,
right, thank
yep.
you.
Any other questions or a motion?
I'll make the motion to move resolution number 2023-03-015R, supplemental resolution for improvement under the Illinois Highway Code, state motor fuel tax for Savannah Green alleys rehabilitation construction to City Council for approval on the consent agenda.
A second.
Great, it's been moved by Chandra and seconded by Mary Alice. Any further discussion? Seeing none, all those in favor, please say aye.
Aye.
Any opposed? That motion carries. Next, we have resolution number 2023-03-016R, supplemental resolution for improvement under the Illinois Highway Code state motor fuel tax for Springfield Avenue from Wright Street to McCullough Street, resurfacing, design, and construction.
I promise we'll get some shorter titles for you sometime. Engineers think if you just keep adding on words, it's still intelligible. This is a bad habit we have. Okay, so Springfield Avenue, this is going to be a segment of Springfield from Wright over to McCullough, and it excludes a section from Gregory Street to Kohler because that section was recently resurfaced with the Lincoln and Springfield resurfacing project that was wrapped up this past year. So we're just kind of, the goal is to provide a smooth ride from the moment you leave Champaign until, I don't know, it just keeps going. It just keeps going. Yeah, just stay on Springfield. But no. So this will be. We're looking forward to this project a lot. What we had in this fiscal year was just for design, and we had started with really just a basic resurfacing project. And as we got into looking at this corridor, and looked at more of some holistic needs in the corridor, such as street lighting, traffic signals, and other considerations like that. And when we learned from our experience with the bid prices we got on Lincoln and Springfield, those factors came together to lead us to increase the scope and budget for this project, which you have not seen yet because it'll be in our new capital improvement plan coming later this year. But essentially, we're going to have going from an $840,000 budget for the project to a $1.46 million budget for the project. So in this case, we believe this is justified by the improvements we can make on this corridor while we're doing the pavement resurfacing. But for right now, we are still just in design. The current budget we have in this fiscal year is for $70,000. That gets us through about 50% of the design engineering efforts. We'll be coming back to you next month for enough money to complete the design efforts. But for this supplemental resolution, so the previous resolution was just for $70,000, that initial design effort. I want to go ahead and advance us to a supplemental resolution that will cover the entirety of design, construction, and construction engineering. And so our current budget for that is $1.46 million. When we add a little contingency on there for construction again, that brings us to 1.56 million. 1.56 million, take away 70,000, leads to 1.49 million. And so that's where that number came from, and that's the number that is on the supplemental resolution that we are presenting to you tonight. So essentially just building off where we started, getting to where we hope will get us through this project. Yeah, like I said, we're in the preliminary stage of design right now. Plans right now are to go to have design completed by the end of this year, go into a fall, I believe in November, bid opening is the plan for construction next year.
Any questions? James?
Thank you. I do. So this part of Springfield, I think when it ends at Wright Street, going to Champaign, it becomes the state's responsibility, right? The state manages it. Does the Springfield?
That's correct, yeah, because
150 or whatever. Yeah.
That's right. That's right.
And can you? So this is like a 75% increase in what we were planning to spend here.
Mm-hmm.
So could you just kind of give us a brief overview of what we're getting for the additional $600,000? What the extra stuff that we're going to get done? Just a few descriptions of what that is?
Yeah. Unfortunately, I think a large percentage of that is inflation. That's the unfortunate reality of this. Is this there are definitely some costs in there. There's some parts of the project we didn't have, and I want to say even the length of it we didn't have. I want to say there was a discrepancy between like when maybe it stopped at, I forget what the street, maybe it's Harvey, maybe it stopped at Harvey. I don't know if I have that right, but a block before Gregory. So there might have been a block we were missing in our capital improvement plan, but a lot of this is just because the prices that we got on Lincoln and Springfield, assuming if they continue forward, is going to be that kind of a budget for this project.
So you're saying we're not getting a lot more for that additional $600,000? From what you said, I could have sworn I heard you say we're going to do some additional things with this.
There
I was
are.
just curious what those additional things.
Sure. We are planning to make some spot improvements to our street lighting in the area, do some improvements with some of our traffic signals. Definitely a lot of sidewalk improvements. But I would say that's not going to account for the majority of the dollars.
Are we getting an overpass for the students at Granger? No, I guess not.
I would love. That would be fun. I would love for the U of I to do that. That'd be great.
Mary Alice?
I'm kind of along the same lines as James. I was taken aback by the increase here, and so in the plan here that you copied out in terms of the right to McCullough is $770,000. Am I correct in saying that this is now it's more than double? Am I correct in saying that?
Yes.
All right, so we are spending an extra $750,000 approximately, right?
Mm-hmm.
And it sounds like there's not a lot of improvements beyond what we had spec'd out in the SIP originally. A couple of little things here and there,
right,
so to speak.
Right.
So, this is my question always. What does this mean that we can't do?
That's the right question. Yep.
I'm looking at Tim.
The next priority. So, effectively, we prioritize our capital improvement plan around the top priority projects. Specifically, it's probably taking away from things in the 5 years, not in the 1 year.
So, I feel very uncomfortable doing an increase such as this without maybe understanding a little bit more about the implications on our SIP plan. It would be good to have some examples so that we know what we are basically deprioritizing to spend this money on. So I don't know if that can be done by the next city council meeting, but that's what I would like to say. Not to say that Springfield doesn't deserve, to be fixed. It's a mess over there. But we also have to think that we only have a certain amount of money to spend on roads. My take.
Any other questions or is there a motion?
I'll move approval of resolution number 2023-03-016R, supplemental resolution for improvement under the Illinois Highway Code State Motor Fuel Tax for Springfield Avenue from Wright Street to McCullough Street, resurfacing, design, and construction to City Council for approval on the regular agenda.
I'll second.
It's been moved by Chandra and seconded by Charisse, excuse me. Any further discussion? Mary Alice?
I just want to say thank you to Chandra for making it on the regular agenda and on the consent agenda. I appreciate that. And because of that, I will vote for it.
Chris?
Yeah, thanks. This is Ward 2, and I will tell you that Springfield is a mess. It needs to be fixed. So there is a great need. And I'm just the musings of an ignorant dreamer here, and no comment needed, but my least favorite expenditure is roads, not because I'm against smooth roads. It's just I'm so frustrated that the asphalt doesn't last 100 and 150 years, you know, and I know everybody else feels the same way, right? But I'll just end with it. There is a great need to get this done. It is unfortunate that the price has gone the way it has. And it's kind of a dismal future, like, is this the way it's going to be from now on? You know, constant increases. I mean, all the CIP estimates that we currently have, are we going to expect higher prices later on? But anyway, so thanks to council to help out this road. Thanks.
Any further discussion? Great. So, yeah, I think getting clarification on what we would be potentially not funding and what we're, maybe clarification on what is the additional would be really helpful. If there's no further discussion, all those in favor, please say aye.
Aye.
Any opposed? All right, that motion carries. Thank you.
Thank you.
Next, we have council input and communication. Mayor Marlin asked to speak first, so Mayor.
Thank you, Jaya. Yes, I wanted to address the comments that were made last week regarding the public realm study and also respond to the concerns and comments that we got this week via email. Just to clarify, the Urbana Downtown Public Realm Study focused on an area that is much larger than the mall at Lincoln Square. That's one thing I think it's important for people to realize. Secondly, and this is something that should have been emphasized in the report, and I will ask that it be put in much bolder and bigger type, but on page 6 of the report, public realm is defined, and that's important for us to understand what the definition of public realm is for the purposes of this study. It's defined as, quote, streets, sidewalks, plazas, alleys, parking lots, transit stops, and natural areas. And here's the important part, as well as all places that host public uses, be they public or privately owned. And that's a big factor in this study. Just to generalize, over the course of 8 months, business owners and operators, members of the public, and a 19-member community advisory committee engaged in the process of generating ideas and concepts to make our downtown more appealing as a place to visit, live, and do business. The area in question, again, as I said, was large. It was bordered by University Avenue on the north, Cedar on the west, Illinois Street on the south, and Urbana Avenue on the east. The goal of this study was to continue to support our local businesses and downtown residents while enhancing places and spaces in the heart of our community. The public realm consultants, the city of Urbana, all of us here, of course, understand that the mall building in Lincoln Square is privately owned. The study was not presented as a plan, or was not intended to be presented as a plan for the future of the mall. That future lies in the hands of the mall owner. And nothing will happen in that building unless the owner chooses to do so. And we will add language to make that explicitly clear in the final report as well. What we had last week was a draft report. We do have an opportunity to amend or change some of the text to clarify for the public. But I also want it to be clear in the report, it did reflect public comments and the ideas that were received during the 8-month study period. And those ideas and comments were presented in the report, along with dozens of other ideas and concepts. For this study, the city listened to the community, and the community members brought up the idea of Lincoln Square. And it's not hard to understand why this was included in a discussion of a public space, given the prominence of the mall in Lincoln Square and the fact that it does host so many public events. It came up repeatedly in these discussions, and that's why it was included in this study. People have always had opinions about Lincoln Square and the hotel. And I can tell you, and they have a lot of opinions about the hotel and the mall. And anyone who has encountered the public and engaged in conversations with members of the public, it comes up all the time. I can't tell you how many times people have asked me, you know, why don't you fix the roof in Lincoln Square? And I'm like, well, I don't own that building. But the line is blurred because it is used as a civic space in so many ways. And I can tell you, if the historic hotel, if the Hotel Royer wasn't currently under renovation, that building would have come up in this study as well, because people view it as part of our public realm. For decades, and to that end, for decades, university planning classes and architecture classes have used Lincoln Square as a project site. And they have developed a number of different visions for that site as well. And not surprisingly, some of those class projects have come up with ideas remarkably similar to what we're seeing in the public realm study today. So the community, what I'm saying is the community has always been keenly interested in this part of our downtown because it's so prominent. It's 16 acres. It's in the heart of our downtown. This area has always inspired a lot of opinions and ideas, and that's why it appeared in the public realm study. But at no point was it ever intended to convey the idea that this was a plan for the future of privately owned property. It was not, and I want that to be more clearly stated in this study so people understand. And I apologize if that wasn't clearly communicated to begin with. The public realm study also challenged us all to think about other downtown areas, not just Lincoln Square. And that's what resulted in this report, which I think is actually very good. It focuses on a number of areas in our downtown, key concepts, themes were emerged from this, and basically it gives us options to explore. Some of the ideas in the realm study turned out to be small scale that we could, if we choose, to implement very quickly, and others are large scale that require significant investment in planning. But that's the key word, investment in planning, and that was not part of this. This was an idea-generating report. The other thing we're getting messages from this week, which were very disheartening to read messages from folks who say that the city of Urbana does not care about small, locally owned businesses or women-owned businesses. And that cannot be farther from the truth. This city, our city staff, elected officials provide local businesses with financial support, ongoing promotional efforts, and daily assistance and service. Just some examples. Over the last few years, businesses in downtown Urbana and Lincoln Square Mall have received thousands of dollars in rent subsidies through our previous gallery incentive program, mainly through direct payments to the owner of the mall and local downtown landlords. The city has also provided business opening grants to the tune of almost $364,000 over the years. Facade grants over the years to local small businesses. One of the facade grants was to the owner of the mall, I believe, when the Common Ground the grocery store was opened. Public arts and culture grants have supported, again, thousands and thousands of dollars, have supported local artists and performers and their activities and programs, many of which have occurred in the mall or in the downtown area. And just in the last couple of years, city, county staff have processed and distributed over $5.7 million in COVID relief funds to local Urbana businesses, including the retailers and studios in Lincoln Square Mall. The public has also invested millions of dollars in infrastructure, including the rebuilding of Green Street from Lincoln Avenue to Ray Street, which basically is the phase 5 of the MCOR project. But that rebuilt the corridor that brings people from campus and visitors to our community directly to the doorstep of the hotel and the mall. And there's other infrastructure as well. The city's the public is about to invest $5 million in the hotel, assuming that they meet the terms of the development agreement. So what I'm saying here is we have bent backwards over the last few years of helping our local businesses both survive the pandemic and thrive. We've waived liquor license fees. We've modified zoning and building codes temporarily to allow for safe indoor and outdoor operations. And we have every day we helped businesses navigate the state and local public health guidelines. So I'm going to say it again. The city, the staff, and this council strongly support local businesses. We provided local businesses with financial support. Our promotional efforts are ongoing, and we provide daily assistance and services to our locally owned business. And I would add to that, we have provided tremendous amount of assistance from our first responders, our fire and police departments in terms of security for our downtown businesses, as well as guidance from building safety officials. So every department in this city has supported our local businesses and will continue to do so. Personally, I'm excited by the potential that I see in this study, and I urge everyone to read the full report. We will be clarifying, some of the key points that I made here, and I urge everyone to help us explore the possibilities, because I think the possibilities are tremendous, and I want to look toward the future, not the past.
Any other council comment? James.
Yes, I'd like to follow along with the comments from the mayor, because I do feel strongly that this is a study. This is it's about concepts. The thing we challenge a group like the one that produced this study is to help us think outside of what we've done in the past. And so to illustrate the themes and the concepts that they brought to us, they picked some things to illustrate what you might do about those. We can take or leave those, but we can, if we leave them, if we don't use them, we can still use the themes. One of the things I won't say disappointed, but one of the things the study missed as far as items it could focus on as possible paths are both the downtown jail and the Civic Center. They do mention the area around the Civic Center as an opportunity place, but they didn't include those as objects or places that could be modified to support the themes that they provided there. And I would encourage people, in particular the individuals who are unfortunately have become really concerned about the mall and the specifics that were included about possibilities about the mall. I would encourage them to redirect their energy to look at the themes and suggest ideas that they would support instead. We have the themes, we have the concepts now that the study centered around that said this is how you can look at this. bring more ideas to the table as opposed to just coming and say, we don't like this idea or that idea. There's some ideas in here that maybe I wouldn't pursue, but it has me thinking, right? One of the things I've always wished for in downtown Urbana is more green space. There's a lot of pavement. There's a lot of buildings that are no longer in downtown Urbana, and we've replaced most of that with paving as opposed to green space. We don't have really a downtown park. There was doing the work around the Boneyard was one aspect of that, but we don't have a commons area or something that you could do things in that's not concrete or asphalt. And so where does that go? Where do you find that? I don't think it's just little triangles here and there. I think we have an opportunity to think bigger about that. And I would encourage everybody to take that turn of, instead of saying no, 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 say, here's how I would do it, because we can still take those ideas and incorporate them in the themes and the concepts that were brought here and move forward. Thank you.
Chris?
Yeah, I mean, confluence is not the end of the design process, right? I mean, and we've got, 20 years to design this downtown, and we need everybody on deck and all ideas. I appreciate what Confluence did and kind of shaking it up and looking at it from a different perspective. It certainly generated a lot of interest all of a sudden. That was good. But they're just ideas. And James is completely correct. What are you for? What do we want? And we're trying to create a business community that attracts people. And it's a place to be, a destination place. And we can do it. And all kinds of ideas are available. Speaking of Lincoln Square, I did want to announce that the 39th annual Lincoln Square Train Show is coming up March 25th and March 26th. Saturday at 8 a.m. to 5 p.m., Sunday 11 a.m. to 4 p.m. This is a model train show that I enjoy every year. It's a great show for kids. Bring your kids, and it's free admission. So, there.
Any other council comment? Grace?
And I'm just going to say this really quickly, because I felt compelled. I didn't put it on my Ward 3 Warrior site, but I felt compelled to just inform the public that the city has no plan to demolish or to cut up Lincoln Square. And that seemed to me to be the theme that was happening and going on during last week and weekend and in the paper and everything. And it seems like something definitely got lost in translation between what a public realm study was and what the city was. And I just, so much stuff gets lost like that now, information-wise, on a national scale and on a local scale, depending on who's talking the loudest. And there was never a plan, there is not a plan to do anything to Lincoln Square, because we've been saying for the past, I know since I've been on city council, Lincoln Square is not owned by the city, no matter how many times, and it's been several times that people have come to city council and complained about Lincoln Square. And every time we say, well, you have to talk to that owner. Well, now you know. So now there's no excuse, because everyone came to his defense. So I'm assuming now that everyone now knows that Jim Webster owns Lincoln Square and will no longer come to city council to complain about the condition of Lincoln Square. I just want to make sure that that's out there for everyone. Thank you.
Any further comments? Great. If no one else has anything else to say, this meeting is adjourned.